Hi, everyone. Thanks so much for attending today. We always appreciate all of your support and attendance and learning some of these topics to do with your wills. So we appreciate you guys taking the time out today, and we also appreciate Matt Trotta from Field Law. Thanks so much for attending, Matt. We're always pretty excited to have you educating us on all these topics.
Hey, thanks for having me.
That's great. So today, just like every other session, make sure that you guys, as we go through this, because we have a smaller group today, so we might actually unmute people at the end and let you guys kind of speak about your own personal situations, because this is a good time when you have a lawyer here to ask your questions and a planner here to maybe ask some planning questions, because of course we always want to do the best job for you. So make sure if you have some questions, put them in the chat section, and if you want to speak, there's going to be, you can put your hand up like this. There's a little hand signal that looks like this on your chat section. You can put your hand up and we'll actually unmute you, and you guys can talk and ask your own questions that you guys have pertinent to your own situation, because you know, at the end of the day, it's going to be pertinent to everyone else on the call's situation. So we also appreciate a good conversation, because that actually will broaden this out for everybody. So thanks again. Sorry, we'll get started here. So the biggest thing about blended families, people often come to us and go, oh, you know, that's really simple. I know what I want to do. And, you know, I have previous kids I want to look after, and I'm going to look after them. And the whole concept of, you know, theirs, mine, and ours is a lot more complex than people think. And I think this topic has been probably one of the most contentious legally before and after with all these kind of things, because people think these conversations are simple. But when you start adding in children and children's feelings and a lot of things that happen, this gets ugly quick. And, you know, we always say it's important not to create mistrust and discord. When we say things like that, like I'll kind of mention an example that we had is, you know, someone moved new mom in, and new mom was a new relationship, right? And all of a sudden, you know, pictures started getting taken down of old mom that passed away. And there was a huge argument about it and huge fights about it, till finally there was, you know, a wall of old family, a wall of new family. And that kind of started off the steps of, well, you better not give her this, or you better not do this. And you know, someone saying, hey, I want to be fair. I don't want to give her everything. I want to give my girls something. And you start having those conversations where it starts to get sticky and it starts to get ugly quick. So when you don't do this properly and you just kind of go, this is the way I'm proceeding, this is what I'm doing, everybody live with it. When it comes down to an estate, no one necessarily lives with it. We've got another big family that's been fighting for years. And when I say years, it's hundreds of thousands of dollars in legal fees, because it's just mine, his, should have been ours, you know, and you get that happening where all of a sudden, you know, the Matts of the world make a lot of money, and also the family lawyers start making a lot of money, because it's just listening to scrapping instead of actually being productive. And the lawyers obviously try to lead that down a productive path, and all of us try to lead it down a productive path initially. And that's really where we kind of start with this, and the whole emotional issues of everything that's with it and the conflict that comes through it. Really, it's dealing with that emotional conflict ahead of time, and in our boardroom ahead of time, let's hash those things out, because that's really what you want to hash out up front, and make sure that everybody feels fair and equal, because fair is not always equal. And that's the thing that people have to realize, especially like, let's say you have a business. It's like the business might grow in value to something that no one ever predicted. And then all of a sudden it's like, well, that's not fair that that person got the business. And it's like, well, you said you didn't want the business and you were happy having this fair issue happen. So that's where, again, communication is completely key through all of this. Okay.
So from here, it's important to kind of understand what we are talking about when we talk about a blended or complex family, because you know there's your conventional answer of what a blended family is, which is a couple and their biological or legally adopted children from a previous relationship or marriage. But you know, it goes a lot deeper than that. And so there may be instances where both spouses have children from another relationship or other relationships. maybe it's just one spouse moving into an existing family unit, perhaps from a divorce or from the former spouse passing away. It may be a situation where both spouses have children together, and then there's also children from a prior relationship or relationships on either one side or both. Or if we have one spouse with children from multiple different relationships, and maybe there's support obligations coming in for one or more of those children, and there could be a lot of different circumstances, but that's really not the end of the story. Blended is just kind of a small part of what complex family situations are and where we have to plan a bit differently. So what we look for as planners to require special consideration and conversation are situations where there's been a previous marriage, where situation, and this does happen, where somebody has a spouse and an adult interdependent partner, and it may not be what you think with somebody holding a mistress at another property somewhere. There can be instances where a family member is an adult interdependent partner of another family member, in situations where they maybe lived together and signed an adult interdependent partnership agreement. And so there may be obligations, not just the mistress, but there may be other things going on. Every family is a bit different, situations are a bit different, so that's something to think about. And a lot of times it may be not necessarily the spouses, the people that we're meeting with that have the blended family situation. It may be their children. It may be a situation where their child is dating or living with somebody who has a child from a previous marriage, and we want to make sure that the gift goes to the benefit of the family versus potentially being subject to a family property claim. Or you may have a situation where people have children at different times, and you may have one child who is well into their adulthood and another child who is an infant. That's a different sort of planning situation, and we're planning on two very different sets of facts. And then, of course, any disability, and the disability may include something that's mental or physical, or it could be something more like substance abuse, or something like gambling addiction, or something where it's both a mental health thing and a habit. So what's important to note is when we have these situations with blended and complex families that, the law of every jurisdiction is a little bit different. But in Alberta, a testator has a legal obligation to adequately provide for what the Wills and Succession Act defines as family members. So this is essentially spouses and adult interdependent partners, minor children, financially dependent children in full-time post-secondary traditionally between the ages of 18 and 22, and now just over the age of 18, with the level of dependency being a question of fact, kind of a case of estate law following family law. And the third one is if somebody is mentally or physically incapacitated, that adult child would be considered a family member. But in Alberta, other than that, financially independent, or even if they're financially dependent but not in post-secondary, able-bodied adult child is not a family member. So you could have a situation where there's an obligation to provide for a new spouse, and hypothetically, that spouse's minor children, if you stand in place of a parent, which is a question of fact largely, or in loco parentis is the legal term for that. But you may not have that same obligation under law to provide for your own biological or legally adopted children. So it means, we have to consider that carefully, make sure we satisfy those obligations, but also still satisfy your estate goals. So what are some of the common things that we see when we're dealing with blended and complex family planning? Well, as Pam alluded to, a lack of communication. A lot of people think that it's best not to discuss these things. It might cause a fight. Well, it will cause a fight if the planning wasn't done properly and there's a situation later. It's important to get the point of view of the entire family. If there's, an issue between stepfather and son, and or something like that, Probably good to know that before you start naming one of them an executor or trustee, where they have a fiduciary duty to the other and putting them in a situation where they may be in a conflict. The second one that comes up a lot, and it's something that we can't really do anything about because we don't know, is a failure to show honesty and candor with your planner, with your legal counsel. So with your legal counsel, what you tell us is privilege. Solicitor-client privilege is your privilege that only you can waive. But it's important for us to know, if there's a skeleton in the closet, it's worse if we don't know, because then we can't plan for it and we can't help you address that. And this may be situations where somebody has a child with somebody that their current partner doesn't know about. It may be a situation where they're paying support payments and they don't want the other spouse to know about it. It could be any sort of situation like that. It may be that they have in vitro zygote in a facility, and they may have conditions on how that can be used and how it can be donated, and depending on the jurisdiction, that could become a problem down the line. So it's important for us to know these things because we can't plan for what we don't know. The general assumption that all parties will get along is a constant issue, whether you have a blended family or a very simple family structure. Parties will always become worse. So if there's an underlying issue, a situation that has added stress, added motivation, financial implications, personal implications will make these situations worse. So we have to go in here with open eyes, be willing to be introspective to say, look, I know my daughter doesn't like my wife. Maybe don't put them in that situation. Maybe we have a situation with a third party administering the estate. Maybe we have different rules governing how the estate works. Maybe if it's a situation where, for example, your son and daughter are going to be running your family business and you don't want your spouse to be a shareholder, well, maybe we have to work something out to make sure that she's financially or he is financially taken care of, but the shares of the corporation are governed separately and administered separately. Generally from there, a lack of family tax and estate planning is always a problem. A lot of people say, well, I have a will, that's enough. No, it's not in a lot of cases. What's important to note is depending on where you're resident and where the relationship is resident, a will may be revoked by a new marriage, depending on the province or state. In Alberta, it's not revoked by marriage. It's not revoked by divorce either, but divorce does have an effect on an existing will. Under the Wills and Succession Act, subject to a contrary intention, a spouse is deemed to have, a former spouse is deemed to have predeceased you, which means if you've named them as an executor, if you've named them as a beneficiary, they're struck out by operation of law unless a contrary intention exists. So what is a contrary intention? It's a question of fact, but if you don't have that, they're out, somebody else is in, and it may affect your plan. In some cases, a former spouse may remain a friend. They may be the best choice to be the executor of the estate because the sole beneficiary may be the child that the two of you have together. For that reason, they may be a bad choice. So it's very important to reevaluate the situation once that happens. And again, sitting down and figuring out which family members should be acting as executors, trustees, guardians. It's important to have that discussion, not just on an estate point of view, but on a family and tax point of view, because interests may not align and there could be issues in residency depending on where they're located. In Alberta, it's not so much of an issue. You could have a foreign personal representative subject to jumping through a few hoops. But if you have assets in another jurisdiction and the estate needs to speak to those, having the wrong person in that jurisdiction could be problematic. And for here as well, this is where prenuptial agreements and cohabitation agreements can be important and something to have and to plan that in advance. And we'll talk about that in a bit more detail later on in the presentation. The next issue, designations and will distributions being incompatible. This happens an awful lot, where somebody will make a designation in their insurance policy, in their RSP, and then they'll say, okay, well, I'll just change it in my will. Well, you have to be very careful about that, because a designation under the Insurance Act is incredibly broad, and you may do something that you may not think that you're doing because you may not have had advice on it. You may have had the designation in a certain way because it was part of a divorce settlement, or you designated it in a certain way to obtain a certain tax result. So it's important for those to be compatible. It's also important from the point of view of dealing with financial institutions. They will go by what they have in front of them. They'll go by their designation, and the will shouldn't be there to overturn that. My personal planning philosophy is that the will is there to address issues in the designation, and to ensure that if, for example, you never change the designation and you get remarried and that spouse is supposed to get everything, that spouse can point to the will and be able to access tax rules that are beneficial for a spousal rollover or a situation like that. It's not necessarily intended to take the place, even though the statute allows it. It can create a lot of issues, and it can be even worse when you have a blended or complex family situation. Question that comes up a lot is, can I do a mutual will because I want to make sure if my spouse and I get divorced that Julio the pool guy doesn't get to march in and take all my stuff? Great thought in theory. In practice, these things, if improperly done and without careful consideration, can raise an awful lot of problems. The problem that people need to realize is that if your spouse remarries Julio or Julia, the pool girl or pool boy, as the case may be, they now have legal obligations to this person under law. They're now subject to the Family Property Act. They're now subject to maintenance and support under the Wills and Succession Act, an adequate provision. And so merely trying to cut things out may not be the solution. We also have a situation where one person may pass away young, and now the second person can't properly articulate what's best for their grandchildren, can't properly articulate charitable or tax goals because they're locked in to an agreement where they have agreed not to change their will because there was an agreed distribution. So there are other ways to do this that are a bit more effective. A lot of lawyers do not recommend doing this, and I'm definitely one of them when it comes to mutual wills. One of the things to think about is direct distribution through an estate. Sometimes that's not the best thing to do in a blended family situation. There are other structures that can be used, such as trusts, where they move outside of probate and probate rules, and things can be structured in a way where gifts are more discretionary. And it's not intended to reduce the rights of a creditor such as a spouse under law, but a way to address obligations in a different way, and a way to help with family harmony by having certain things moving outside. Often people don't consider their family businesses or other privately held corporations when they're going through blended and complex family planning. And kind of what we were mentioning earlier with having a family business and a new spouse, maybe that wasn't the plan, and we need to consider, should this person be a shareholder? Perhaps you're in business with with arm's length persons that don't want to be in business with your family, and in a situation of an untimely passing where you aren't able to retire and redeem your shares, what happens then? And this can be worse when you have a situation where there's multiple classes of beneficiaries that may not necessarily agree. So it's important to have that figured out in advance. Burial and funeral arrangements are very important and often overlooked in this sort of situation. This is especially critical in a situation where somebody may be a widow and their predeceased first spouse is buried somewhere, and they want to be buried with them. And if your wishes aren't adequately communicated and adequately dealt with, your current spouse may decide that they don't want you there, or your family may decide they don't want you there. And unless that's specifically articulated, that can be a problem. So it's important to consider things like that very clearly, very carefully. Poorly conceived and drafted testamentary trusts kind of ties part and parcel to the discussion of the mutual will and the ruling from beyond the grave and trying to protect from these situations. To me, it's important to point out that testamentary trusts are public documents. When you probate a will, anybody can pull a copy of it. So these can be things that can be reviewed and attacked a little bit more, and they tend not to age well. So if you have a situation where you're trying to prevent something from happening, you may be creating a different situation. So it's important to evaluate what the goals are. And again, maybe the solution isn't using a will and having a convoluted testamentary trust. In some cases, a testamentary trust may be what you need, but in some cases it may not be. And the last common issue, transferring assets into joint ownership without proper legal advice. So this is something that we've discussed in earlier presentations, but it's really quite important because if we're moving property away to defray a creditor, such as a spouse, that's a fraudulent preference and it can be undone. We move property to a child, that still could potentially be undone. It may be considered a constructive trust if it's not clear that there was an intent to give with the other children. It may be an issue where the spouse has a right to it, and when people aren't careful with that, we can run into some problems. There can also be some tax issues that arise from moving this improperly, and really considering who's going to be involved on that joint ownership and that inter vivos transfer is something that should be considered carefully and not done on a whim to save money, because at the end of the day, litigators cost more than solicitors.
So now that we kind of know some of the issues, of course, we've got some tips for maintaining family harmony for some of this. So of course, we always say, which, again, goes back to Matt's point, this is the most difficult thing to do. And I don't know why it actually occurs mostly with blended families, is that, the spouse always says, hey, I'm doing what I've always done. I'm doing what I am doing. I don't need to discuss it with you. I've got it handled. I've got everything on my side dealt with. This isn't rare amongst any blended family. So what we try to do is get people talking right off the bat. And, I might say that to everybody ad nauseum. And they go, well, they're just doing their thing. They're running their bank accounts. They're, doing their own business. They're doing their own stuff. They're not discussing any of this with me. Well, just like a new marriage and how we tell a lot of young people who are getting married, have those money conversations, have those kid conversations, because of course, not everybody has the same goals, but this becomes, usually when you get into a blended family, you tend to find people are a bit older, not always, but sometimes, and they're kind of stuck in their ways in some senses, but this is where a lot of the problems arise, and people are shocked with tax, people are shocked with problems that come up. Or, they've gotten into the relationship like a prenup right away and saying, hey, we've got this, but then all of a sudden 10 years down the road, they're like, oh, I've been with her for a long time. I'm willing to give her everything, but you haven't gone back and changed anything. So that's where, again, things stand if you don't change it, if you don't talk about it, if you don't review it. Relationships change, properties change. And again, when you come into something with a joint asset, you might say, okay, we are owning this jointly, but are you really doing this jointly, or are you just inheriting that person's problems? Because you have no idea the debt they have. You have no idea who's after them from a creditor standpoint, especially if they own a business. What really is on that backside? How much do they really owe? And a lot of people have found out, husbands have $100,000 to $200,000 in debt, and all of a sudden creditors are coming after them, and they're like, okay, I didn't know. And all of a sudden you've signed off to do something joint because you just love them and you want to be with them and you want to think it's okay. And it's just not. And that's really, we've come across that while people are in that plan, but we've also come across that when they've passed away. And that just becomes a big mess. So of course it's like, same thing. We've had multiple people do prenups and use a great family lawyer. Matt's not a family lawyer, but we work in conjunction, and Matt works really closely with us and that family lawyer to actually get these documents done and make sure. But then we've had people phone and say, oh, I really want to do this world trip, or I want to do this cruise, or I want to go here, and I'm going to pay for him or her, and I'm going to go, and then I'm going to pay this, and I'm going to pay that, and I'm going to buy them new clothes, and I'm gonna, get a new property somewhere else, and I'm gonna put them on joint. but yet your prenup says all the way along you're not doing anything in regards to that because you guys are sharing money separately. So our role is to kind of go, well, hang on, because you guys said this in the prenup and now you're straying over here. Do you want to actually be with this document, or do you want to be over here and redoing that document and changing everything? Then they're like, well, no, I still want this to stand, but this is just an exception. And it's like, realize sometimes those exceptions become really great court discussions in a court of law, saying, well, he's always done that. He paid for my family, he paid for me, he paid for everything that I wanted to do. That doesn't stand with I'm paying nothing. So that's where we start having those discussions to make sure that that happens. And if you pass away, that becomes, well, this is the standard. And a lot of people don't realize that with prenups is, you know, it comes down to, in a court of law, what's the standard? What's reasonable? What have they been doing? It's all burden of proof, as they say, you know. So what can you prove? And if you're straying off of what your plan is, that's why you want to be open and honest and have those battle out discussions. I usually say it's easier over a boardroom table with all of us in attendance, because usually the spouses aren't as nasty as they will be to each other. And that happens too. And hopefully it doesn't, but it does. So, you know, it happens in every family, I'll be honest, but especially this. And when I say here, update your beneficiaries on everything, I can kind of tell you a couple scenarios that's happened in estates. Is we had an older gentleman that actually was the parents of one of our clients that had a pension and had insurance on the old wife. When we went through the divorce documents, because of course she got his old pension because he had had a pension that he retired 20, 30 years before, and they've been retired for a long time. And so all of a sudden he passed away. All those pensions were actually signed off with a spouse prior. When we looked at the divorce agreements, nothing was written in the divorce that, you know, it was against any type of estate stuff. So then of course you're discussing new divorce law. Does this count? Does this not count? And some things like that stick. And some things like insurance policies, they stick. So usually people don't realize is segregated funds, insurance policies, they bypass your estate. So for this gentleman too, he had an insurance policy, and we've actually had 5 people show up that way that we didn't even know about these insurance policies that people had done back when they were young, and they forgot about them, got divorced. The address still went to the ex-wife or ex-husband kind of thing, got divorced. Those policies still went. The person didn't even remember doing them, didn't even remember anything about them, didn't check mail, you know, and then all of a sudden the wife's getting paid out, you know, $500,000, the ex-wife, and people are going, well, how did she get money? And, you know, she's kind of like, nah, 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 nah. But that's the reality of how these things happen. And then you tend to find people become vocal about it, or they've left something to kids that the kids go, oh, I've gotten this now. And then all of a sudden people are like, hang on a second. And they try to fight it. Those things we don't always know about, and then they'll go and bypass the estate and they go directly to those people. So you've got to make sure that you understand that if that's going to happen, you want to make sure that you're prepared, you have all your documents, you have all your ducks in a row of what you bought, what you don't have, making sure it pays out, who the people are that you want it to pay out and how. And RSPs become another big thing, as everybody says, you know, like, we've got 2 families. So he's got kids, I've got kids. I want all my stuff to go to my kids. He wants all of his stuff to go to his kids. But all of a sudden it's like, okay, now the RSPs are taxable. Now the pensions are taxable, where you could have done them to each other had that class, which Matt will discuss too, because that's really important, as people have to realize is you have to make plans for that spouse, as he's talked about. There actually are rules around the fact that you have to do that, right, Matt?
That's right.
So you make provisions for those people and you have to do that. But all of a sudden you're doing everything to your kids, you haven't made provisions for them. And then they say, oh, they could have the house, but then I want the house to go to my kids. And it's like, what happens if that husband then moves into that house and you haven't done it properly? Husband moves into the house, gets remarried. All of a sudden his new remarriage and her young kids have now all moved in. And how do you get them to leave if you haven't done this properly because you want that house to go to your kids? And then they stay there for the next 20, 30 years. that might not be what you want. And if you haven't done it properly, that's where stuff starts going all over the place. Or if they have a business and people start coming after it, well, the house becomes an asset they can go after. So, you know, those are the things we want to start thinking about, is how do these properties play in? How do the money play into the scenario? Because you really want to make sure that that happens. We even have, right now, we're dealing with a client's parent that lives off of a pension of her ex-husband. And the new wife is already fighting it legally and wanting to take her name off of it. And they're in their 80s, late 80s, and he's now got terminal cancer. So this is where the fight's coming in, where she's like, well, I should be entitled to that pension, and he's never changed it, never done anything with it. And he's been paid out most of it, and he's now terminal. The lawyers can't sign off because he's not well. And so, of course, you've got a situation where things can't get changed, and not easily anyway. And it's starting to, you know, daggers are out, and this other wife needs it to live, because if she didn't have that pension to live, that is her only source of income besides government benefits. So then that becomes pretty intense when you're kind of going, okay, how do I support my mom now if she doesn't have enough money? And so you can see how that trickles out even at that age. You start kind of going, it can be a really big deal, which is unfortunate. And, you know, someone who can't afford legal fees to fight on the other side either. So then the kids are trying to step up and getting involved with it. So again, you know, this is where you want to involve us as your estate planning team to kind of go through all those documents and say, well, here, you know, have I named my spouse? Because it's amazing at how many people have done a pension and they thought they had named their spouse and they hadn't. Or they chose no rights because they wanted more money, and so then it doesn't pass to a spouse. And they're like, well, I didn't know that. And then all of a sudden they retire, it's different. And then if they pass away, that pension ends at their death. And a lot of people don't know that either. And so it's like, it's paying attention to what you're doing, making sure you have that second and third set of eyes on that, to make sure that that's happening the way you want it to happen.
And so what do we do in these sorts of cases? I mean, table stakes are comprehensive will, enduring power of attorney, and personal directive. And Pam raised a really good point a little bit earlier on about, you know, the use of a property. And I think it's really important, and this is where comprehensive will is important, to know the difference between a life interest and a right to use a property. So a life interest is the right to hold and to have the title to that property for your life. And then upon your death, it goes to the fee simple holders. So there are situations where if a will drafter isn't careful or not paying attention, they've given this person the right to that property for their entire life. And that may not be the goal. So that isn't subject to remarriage. That isn't subject to not paying the estate for use or anything like that. That is until they die or until they terminate their own life interest. And this can be an expensive issue to deal with, even where all the parties are all on the same side. I've done a couple where we've seen a will that it was a life interest and neither party wanted that, but we had to go to court to change it, and that's not a cheap application. So it's important to know the difference. In a lot of cases where we're adequately providing for a spouse, where they have means as well, and we want them to use the property, it's usually a right to use that's subject to a few conditions. We make sure that the conditions that we give meet or exceed the Wills and Succession Act requirement for the surviving spouse and partner, but essentially it's a right to use until they choose to move out, until they remarry, or until they commit a breach, which is usually a failure to pay for tax and utilities and upkeep or whatever the situation calls upon. But it's a very important difference and one that's often overlooked in a non-comprehensive document. From a business point of view, a unanimous shareholder agreement is absolutely critical and often overlooked. We tend to call these a corporate will for a reason, very important reason. This is how we govern a corporation. A will is limited on how it can speak to a corporation because the will doesn't control the corporation, it controls the shares. And there's only so far the shares that you hold can dictate the actions of others in a corporation. So what a USA does is it's a specific type of shareholder agreement signed by all shareholders at the time created, binds all subsequent shareholders, regulates the business, and regulates and importantly restricts the powers within that of the directors and otherwise. This is important because it can provide for how insurance that's held by a corporation is used for the death or incapacity or other terminating events of key personnel or shareholders. It can require a legal representative, an executor or attorney to have to sell the shares and on what conditions and on timelines, or it will allow them to keep the shares and on what conditions. Usual examples of that are incapacity, death, or if we have a situation where a disqualified shareholder is going to be receiving the shares. So in some cases, a disqualified shareholder may be a spouse, it may be a sibling, it may be a child, depending on the nature of that corporation. We may say only these people can hold shares, otherwise there has to be an agreement of the shareholders, which can be reasonably withheld. This also provides the opportunity to limit recourse or rights that a person may have to a share held by a spouse, which can be important for family law purposes. As mentioned, it can restrict the issue and transfer of shares, require the approval or a percentage of shareholders, and this helps maintain stability because it's really often overlooked that the family business may be affected by a planned or unplanned departure, and this is a tool that isn't subject to estate law. It's a corporate document, and it allows a little bit more flexibility and a little bit more certainty on how a business is maintained. We may have a situation where we want a successor employee to be able to buy in, or a family friend, or some sort of situation. And you don't really want to have that in a will to try to govern a corporation from a personal document. This is where USA is really handy because there are things that affect your estate that aren't technically part of your estate. USA is the big one for that. We've discussed a lot the importance of prenuptial agreements, cohabs, marriage contracts, postnuptials. They have a lot of different names, but they have one really important purpose, which is to govern the property of the relationship. But it is important to note that parties can't contract out of maintenance and support claims because that is a function of statute, and courts maintain the right to determine if somebody's been adequately provided for or if the estate needs to pay maintenance and support to that person. And this is where Pam was talking about earlier about if you have a cohab and you're actively deviating from it for vacations or other sorts of things, this can become problematic because when you have a maintenance and support claim, what you do is you often will look at the budget of this is what I lived on, this is what I had during this life. So now I'm seeking that because what I've got from the estate doesn't cover that, or what I have when I'm entitled to under the prenup may not cover that. So it's important to know, to be very aware of that. And maybe there's paying for vacations, but maybe it's reciprocated, but it has to be understood because that's one part that we can't really contract out of. Prenups are also useful to clarify the relationship of a spouse and a child. Is this the be-all, end-all? I wouldn't say so. This is more venturing into family law here, but effectively, it states the terms of the relationship, which can be useful. They're useful to deal with deal with situations where we may become adversarial in the future. Usually, when you're dealing with a prenup or a cohab, the idea is that it's a collaborative situation that's dealing with a what if, sort of akin to insurance, where you don't want your house to burn down. Just in case it does, let's have an open and honest discussion on what that looks like. How does that affect, a divorce or a death? Other really important things that are useful are discretionary inter vivos trusts. These are really important because they move outside of the estate. They allow quicker access to money. They can hold different types of things. We can have different beneficiaries than under a will. We may put things into what we call a self-benefit trust, which is effectively an alter ego trust, but slightly different. And what that is it's a trust set up for your benefit in your life and then upon your death to a set of beneficiaries. A joint partner trust is a similar concept where it's a trust that's established for your benefit and your partner until the death of the second of the two of you to die, and then you have a different class of beneficiaries after. This can be very effective in splitting up the estate and being able to allocate what we want things to do for blended families. Something that's often done is, we take a set of the estate that maybe came from a first spouse that passed away, we put it into one of these trusts with the end beneficiary being the children of that first person. This allows a little bit more testamentary autonomy for that second relationship and any rights and obligations that come that way. And then, of course, spousal trusts are very important, both in life that are separate trust deeds or testamentary documents. And it's important for these to be drafted carefully and important for them to be drafted with a mind to the future potentially. In order to have spousal trust treatment under the Tax Act, the only person who can receive income during the life of the spouse is the spouse, and nobody should be able to receive capital other than the spouse during the life of the spouse. So it's important when we draft these is to have a fine line between ensuring that there's leftover estate for the intended beneficiaries, but also not restricting it to the point where the spouse doesn't have the access to capital either. And it's important in any of these instances when we're putting assets into trust that independent legal advice is sought for each partner, because it could very well be a situation where there isn't an issue, but the spouse wasn't aware that property was leaving the hands of their spouse to go into a trust to which they don't have a right anymore. This can also be important in tax reorganizations of private corporations where we're maybe doing an estate freeze where we're crystallizing the value of the shares held by wife, and all the future growth is going to a test or inter vivos trust where the children are the beneficiaries, where husband now has less of a recourse because the trust owns the growth. Their spouse that they would have a claim against has a crystallized amount of share value, and that's it. Did they want that? Did they know what they were getting into? And it's very important to know that the tax lawyer, the estate lawyer doing these plans is not the independent legal advice for both parties.
Yep, and we have had many situations that way of people who have done the crystallization of shares, and the wife's fully aware, and you want to have those conversations of saying, is that income enough? Is it good enough? Then you can leave the business to the boys or to whoever you want to leave the business to, but you've got to make sure you've constructed that accurately. So family meetings. So basically what this all comes down to is something that we do quite often is what's called a family meeting. So family meetings often involve myself, would involve Matt, would involve any other lawyers that might be involved in your situation, a family lawyer. And oftentimes it involves a charity. And the charity might be people that you actually are working with quite closely, and something that the family really believes in, and you have part of the estate. So that not only do they understand your family, but they understand your family's goals of what you're trying to achieve with the charities. They may not be involved in, the whole hash down fights of everything, but they would be involved with the charity portion of saying, what's your goals? What do you want to achieve with this charity? What do you expect them to do? And people often don't even think about that. And we have so many charities that love to be involved with the family. They know the family, then they know the children later if something happens. It's like, and then they're involved still in their life and what their objectives are in the charity, and they're able to talk about different things and have some input to it. And it's pretty exciting when that happens, because you start seeing all of that. One of our first estate meetings was actually Tom Deans, who wrote a book called Willing Wisdom. He also wrote a book called Every Person's Business, which of course talks about business shares and all the things that Matt just talked about with the USA, and how important it is to talk about that and making sure that you've had all the business transactions transpiring how you want them to occur. A lot of people are like, oh, I've had my friend do up my will, or I've had someone I know that I really trust with all this stuff, and it's just going this way. And it's like, you can tell even from our review, we've often brought those up in meetings saying, it's not enough. This isn't what you think it's going to do. It's not going where you'd like it to go. And that's where you want to be really clear and making sure that you're aware of not only, what does their will say, but how does yours work with it? And is that really what you guys want to do? And having those open and honest conversations, because then, again, across a boardroom table in front of lawyers, people aren't going to bat it out. Sometimes they do, but at least it's you can deal with that discord and feelings, because there are a lot of feelings with all of this. Is you might feel happy, but you might feel pissed off, and you might feel that that's not fair, and you might feel, and all of those feelings are what we want to discuss. Is saying, what is that feeling? Let's just go through it. Let's talk about fair versus equal. Let's talk about what you want, what you're trying to achieve. Let's make those adjustments along the way so that we're not having to deal with this mess later on that'll cost your estate more than you ever imagined it would. Same with family and circumstances change, and relationships change. So you might start off really loving each other, and then you might go, I really can't do this anymore. And I've got this prenup, and I'm not well, or, I've got other things going on in my life. And, that's where, again, it might not have seemed like a good idea, but maybe it is a good idea, but maybe it isn't a good idea. And that's where let's review what those ideas are and the feelings and what's happening, and then we can adjust. A lot of people think once they've done a prenup or they've done a will, it can never be changed again. We review those with our clients every 2 to 3 years, and we start, pushing on the fact that that probably is more important. Like, people look at returns on their money and what's happening in the markets a whole heck of a lot more than, did I actually update anything with my will? Because people go, it's done. Well, it's not probably done. And like we're seeing, even with doing all these webinars, people are sending us their stuff, and some are done by great lawyers that, we thought, okay, well, that person totally, and then it's like, what is it here? What's happening? Well, this wording from 20 years ago, ooh, that doesn't work anymore. Tax rules have changed, laws have changed. And all of a sudden, it's like, that wasn't the intention that you were going for at all. And that's where, again, you want to make sure that we're updating those things, and we're going through all of it. Why I want to mention family cabins is because, of course, we're seeing this come up more and more, and I know Matt is as well. And a lot of people have property in multiple places. So whether, that's where we're talking family cabins. It's not necessarily an inherited cabin that's gone on generations. Some have, for sure, and we've dealt with that too. But some are multiple properties. Like, some people, there's a couple of people on this call that have multiple properties in different jurisdictions. And again, making sure you have the wills in those different jurisdictions, making sure you have them owned the way you want to have them owned with different people. That's going to be really important, because what we have seen is all of a sudden the blended family splits up and someone passes away, and all of a sudden, well, that wife was part on either their estate or they're part on, all of a sudden, the cabin that the other family members didn't know about. And all of a sudden they're now traveling with said wife that passed, that still exists from the past relationship. Now she has a new husband, and they now have kids together, and they now show up at the family cabin with your whole family that you've known your whole life. And all of a sudden this might be the new wife that was around for 2 years before he passed away. And people are going, why are we traveling with their kids? And then all of a sudden their kids start taking over the family cabin, and there's lots of arguments and lots of things that happen, and legal flying around everywhere, because of course people are unhappy, or they just fight it out. And I've seen that happen more often than not, as people fight it out, and then it's like, well, I'm going to show up every weekend so that they can't. And it's just misery. And as we're all finding out with pandemic, life is a little too short for that. So I think that's where you have to start hashing this stuff out. Live the life you want to live and how you want to live it. And, be above board to discuss all of these things and discuss the businesses you run, and really discussing the family cabins. You probably have some stuff to add on family cabins, Matt, that you've seen that you would like to add here too.
Well, I think that's a really good point. I mean, the family cabin gets exacerbated really easily based on a family circumstance. I mean, they already can be very difficult if it's, a family where it's mom, dad, and the kids from the original marriage. It gets even worse when it's, well, now what about my spouse's kids? Or if you have a situation where there's 10, 20 30-year age gap between the children. Well, the youngest one isn't going to be able to maintain the property to the same level as the other two, most likely. So how do we govern that? And it's one of those situations where we have to be realistic a little bit about it and say, can the family cabin go on? How do we deal with it? How do we address this interest? Maybe we dispose of it before there's a fight. Maybe it goes to just one person, but again, you have to be very careful with the competing legal obligations that may exist and making sure that we've adequately provided for the spouse. And in an absence of a cohab or a prenup, it gets a lot more uncertain about what is actually adequate, both on a property right under the estate and maintenance and support rights. So something we have to consider very carefully, plus the idea that property that's situated in another jurisdiction tends to be governed by the laws of that jurisdiction. So we have to be very careful about that as well.
Awesome. And so again, you can raise your hand if you have a question. We'll unmute you. If you have a camera, you can go on the screen. We can put you up on the screen and you can just raise your hand on the questions, or you can just type your question in the chat section and we'll go through some questions that people have and have on their own situations, because I know it'll apply to probably everyone in the group. So does anyone have any questions yet, Jeff?
Yes, Pam, we have a couple questions. The first question comes from Barb. She's asking, I'm currently separated, now with a new spouse. How long can my ex come after me for all of my assets?
So this will depend largely on whether or not things were properly filed and the divorce was finalized, whether or not there was a cohab or a prenup governing the relationship. From an estate point of view, typically how it would work on death is the surviving spouse, if that person is still considered to be your spouse, would be served with a grant application noting their right under the Matrimonial or the Family Property Act now, as of January, and the Wills and Succession Act. They'd have 6 months from the issuance of the grant to make a claim, and after that, their recourse would reduce to the value of the estate that has not yet been distributed. And once the estate is fully distributed after that period of time, their recourse is gone. From a family point of view, when everybody's still alive, we'd have to refer that out to a family lawyer.
And of course, that comes down to, again, why we say you go to see a good family lawyer. We're seeing more and more groups pop up that they're mediators, they're not lawyers, because there's lots of lawyers that are mediators and they do mediation law with family law. But we see a lot of people who are now divorce experts, and they're not legal, they're not certified in any way, that are giving people a lot of advice in respects to law and saying you could go down to the land titles office, you can change your property yourself, you can do this all yourself with our help. Spend the money on a lawyer, because if it's not done properly, again, like Matt said, is all of a sudden if there's maintenance or support that they feel they deserve because they've lived a certain lifestyle, all of a sudden this becomes a huge estate issue later. And of course, if you haven't got anything written in a divorce agreement that, they're not entitled to anything, that should be written in a divorce agreement. That was written in my divorce agreement, making sure that that person has entitlement to nothing in your life, and it's spelled out just so that, if it ever came out in a court of law, that's all there. You want all of that there. That's really what lawyers are there to do, is not to charge you money, but to protect you. I always call Matt and all of his whole team and everybody your security blanket, because when you need that security blanket and you'd like to hide and cry over something that's happening in your life, they're your Superman, they're your Batman that comes down in their big capes and they're there to protect you. That's really their job. And that's what you're paying them for. You're paying them for their support and their love and their caringness that you put in those documents. And they will fight for you far more than sometimes people are able to fight for themselves.
I think that's a really good point. We like to think that we're superheroes, but in reality, it's sometimes the best ally is the facts and acting in a timely manner. There are statutory limitations to claims, but in a lot of situations, it's better to, as Pam said, get out there and get it dealt with, and get it finalized, and get it properly negotiated, so that there aren't loose threads that remain after the fact, including property that maybe wasn't addressed in a divorce proceeding because it was a DIY job that forgot to deal with certain aspects. So very important for that sort of situation, for peace of mind, to get it done properly and expediently.
Thanks, Matt. Thanks, Pam. Next question comes from James. He's asking, what happens if my beneficiaries live in other jurisdictions?
So with that, from an estate point of view, the estate is governed by the province that it's in. So if it was an Alberta estate, just because the beneficiaries are somewhere else, doesn't necessarily mean that there's different rules that apply. From an estate point of view, depending on where the beneficiary is located, there are some foreign jurisdictions that do have an inheritance tax to be aware of. If you have assets in other jurisdictions, you may have to apply for probate in that jurisdiction. So that's something to be aware of, and to be aware of the executor. If you have a situation where your beneficiary is resident in a jurisdiction and may be subject to a community property law, such as in some states in the United States, I think it's important to kind of figure out in advance what the rules are in that state, because while there may not be a claim while it's in the estate, once you distribute it to that beneficiary, have we now added that property to be subject to a claim? And is there a better way to do it, to maybe gift it to a different family member, or to set up some cross-border planning? So it's important to evaluate that in advance.
Thanks, Matt. So we don't have any more questions at this time. If anything comes up after this webinar and you'd like to ask, feel free to send us an email at info@thetowergroup.ca. We'll also post this video on YouTube. Don't forget to like, subscribe, and comment. And I'll pass it back to Pam, and we'll finish off the webinar for today. Pam, take it away.
So thanks again, everybody, for attending. If you have any questions pertinent to your own situation, again, you can raise your hand before we go off here, and we can definitely unmute you. Don't be shy, because of course this is a good time to ask those questions, honestly. So we'll wait another minute or two, and otherwise, yes, thanks very much for attending, everybody. And again, thanks, Matt, for this great knowledge, because of course it's as you can see, a lot trickier of a subject than a lot of people kind of anticipate it's going to be. And as you see the detail in here, it is a lot trickier than people assume.
It was my pleasure. And like you said, it's a complex situation that every family is a little bit different, and it just takes a little bit of time to analyze and come up with a good plan of action that will hopefully get the result that we're looking for.
Awesome. I guess we have no other questions. Okay, well, thanks very much, everybody. Talk to you soon. Thanks for attending.
Thank you.